Hello, this is Robert Perkins, the immigration professor, and welcome to the third video in our three-part series on unlawful presence and unlawful presence waivers. You can see all of our videos on our website, www.immigration-professor.com, or if you have a question about a specific case or need representation, please call our office at 310-384-0200. We represent clients in immigration matters all over the United States and also overseas at different embassies and consulates. So, in the last video we talked about waivers or pardoning unlawful presence and what were the sort of legal standards for that, or what do you have to prove. And in the first video we talked a little bit about what is unlawful presence. Again, the most common thing we see is when somebody has entered illegally, they've been here illegally for some years, and they're married a U.S. citizen. And they run across this problem. What happens? Well, this video we're going to talk a little bit about what is the procedure for getting an unlawful presence waiver. The procedure has changed over the years, and it really depends a lot on where you're from, too, in terms of whether it'll be granted and also what the procedure is. One thing I want to emphasize that I hadn't touched on in prior videos, although there's an article on my website about immigration through marriage when someone's illegal, which is that there are certain people who qualify to immigrate in the United States on the basis of marriage or another petition under a law called Section 245I. And they may be covered, even though that law expired in 2001, someone may be covered if they filed something sooner. If you have a question about that, please call our office. We'll do another video on Section 245I, but for now, let's focus on unlawful presence. So, you've married a United States citizen, you want to get your green card, you want to get your paperwork, you think, okay, you come to the lawyer's office and you think, okay, we can process this is easy, I'm going to get it tomorrow. Well, unfortunately, it doesn't quite work that way because of the unlawful presence bar. So what happens when someone's here illegally? What do they need to do? Well, the first step that our office does is to say, we have to file a marriage petition in the U.S. That's called an I-130. That's the form that is filed along with different supporting evidence to that form. And that form is filed here in the United States, even though the person ultimately is going to have to go to an embassy or consulate to actually pick up or get their green card. It usually takes a year. I'm speaking now in February 2010, and the current processing time, this is a rough processing time of an I-130, is about 1 year. So let's say immigration says, okay, we've approved the I-130, we believe that this marriage is legitimate. What happens next? The case is then forwarded to the National Visa Center. We call that the NVC. It's in Portsmouth, New Hampshire. And the NVC then collects more documents. They say, okay, this person looks to be ready to immigrate on the basis of marriage. The center does not look at whether this person may be barred by unlawful presence. They don't even review that issue. Immigration does not review that issue when you file your I-130 at all. They just look at whether the marriage is real and so forth. So the National Visa Center then collects more documents showing the person is otherwise eligible for immigration. And they then forward the case over to the embassy, so for an interview. And the embassy will then schedule a marriage interview, basically. At the interview, the embassy is really just looking at, is this marriage valid, is it real, or did somebody marry for papers? But the embassy is also there to identify different bars to immigration. There are, of course, bars to people that have committed serious crimes. There's bars to people that have medical conditions that might be contagious. And unfortunately, one of the most common bars is this unlawful presence bar, which we talked about in part 1 of our videos. So, if somebody does fall under this unlawful presence bar, then the embassy will have them submit a waiver. And the waiver is done in a form called an I-601. However, there has to be a big packet of supporting evidence. When our office prepares cases, we prepare affidavits from the U.S. citizen relative, from other people attesting to the extreme and unusual hardship that the U.S. citizen relatives would suffer if the person is not allowed back in. The I-601 waiver, unfortunately, the embassy doesn't decide the I-601 waiver. It is forwarded to the nearest immigration office overseas where the person lives. For example, if the person lives in Mexico, the I-601 is forwarded to Mexico City, even though they may have been interviewed in Ciudad Juarez, Mexico. So what happens after that is it could be some months, and it's been actually even over a year, and that person has to wait in Mexico or that other country before the I-601 is decided. Again, you can see all of our videos on immigration topics on our website, www.immigration-professor.com. Or if you have a specific question on your case, you can call us at 310-384-0200. So again, the waiver case is forwarded over to the immigration office overseas, and they could take some months to decide this case. One thing I want to mention is just kind of a trend, which is that there are a lot of these cases in Mexico, and Mexico tends to be okay about granting these cases and really looking at the paperwork and really making a decision on the hardship. In Europe and other places of the world, the extreme and unusual hardship standard is extremely hard to meet for people. So they really have to have such an amazingly strong case as to be almost unbelievable. So it's much easier to get a waiver in Mexico, or if someone's a resident of Mexico, as opposed to other countries, at least as of the time of this video being made, which is February 10th. So let's assume the waiver is granted. Once the waiver is granted, then assuming there's no other issues, the person then enters the United States as an immigrant or with a green card. If the waiver, however, is denied, then the person does have the right to appeal the case, and it does take a long time for these appeals to be decided, but they do have the right of administrative appeal. So that's, in essence, how unlawful presence works. And if they lose their appeals, then they have to wait outside the United States for either 3 years if they've been unlawfully present for 180 days or more, or they have to wait outside the United States for 10 years if they've been unlawfully present for more than 1 year. And that's even if they're married to a citizen and even if they have kids and so forth. So it's really important to well prepare an unlawful presence waiver and to have attorney representation in this process. Again, you can see all of our informational videos on our website, www.immigration-professor.com, or alternatively, if you need our help in a specific case, please call our office at 310-384-0200. Thank you very much.